In November 2025, Congress passed the Epstein Files Transparency Act with overwhelming bipartisan support. The law required the Department of Justice to release all federal documents connected to a high-profile criminal investigation. On January 30, 2026, the DOJ released millions of pages of documents. But Congress immediately questioned whether the release was complete. Today, we're examining how government transparency laws work, what happens when Congress demands documents from the executive branch, and why this case raises important questions about accountability and oversight. This is an educational analysis of the legislative process, executive compliance, and constitutional separation of powers. To understand what's happening, we need to examine how transparency legislation actually works. The Epstein Files Transparency Act is a specific example of what's called mandatory disclosure legislation, laws that require executive branch agencies to release documents to Congress or the public. This type of legislation has historical precedent. Congress has passed similar laws requiring document release in cases involving government operations, criminal investigations, and matters of public interest. Examples include the JFK Assassination Records Collection Act of 1992 and various Freedom of Information Act provisions. The constitutional basis for these laws rests on Congress's oversight authority. Article 1 of the Constitution gives Congress the power to conduct investigations and demand information from the executive branch. This power, while not explicitly stated, has been recognized by the Supreme Court as inherent to Congress's legislative function. However, transparency laws often include exceptions. National security concerns, ongoing criminal investigations, privacy protections for victims, and attorney-client privilege are commonly recognized reasons to withhold certain materials, even when disclosure laws exist. The tension arises when the executive branch interprets these exceptions broadly, while Congress interprets the disclosure mandate broadly. This creates what legal scholars call an interbranch conflict over information access. The Epstein Files Transparency Act passed with near unanimous bipartisan support in November 2025. This is significant because transparency legislation rarely achieves such consensus. Let's examine why this particular bill gained such support. The legislation originated from concerns about accountability in federal law enforcement. Representatives from both parties co-sponsored the bill, citing public interest in understanding how federal prosecutors handled the case and whether proper procedures were followed. The bill required the Department of Justice to release all unclassified federal records connected to federal investigations into Jeffrey Epstein and related matters. The language was intentionally broad to prevent selective disclosure.
Importantly, the law included a 30-day deadline from enactment. This timeline provision is crucial because it creates a specific, measurable compliance requirement rather than an indefinite mandate. The law also specified exceptions. Materials containing child sexual abuse imagery would be excluded, victim identifying information could be redacted, and certain law enforcement sensitive information could be protected. But the baseline presumption was disclosure, not withholding. On January 30, 2026, Deputy Attorney General Todd Blanche announced the release of what he described as compliance with the transparency law. According to the DOJ's announcement, they released approximately 3.5 million pages of documents, along with thousands of images and videos, after conducting redactions for victim privacy and other legally protected categories. The Department of Justice stated that they had identified approximately 6 million potentially responsive pages total. After review and redaction, roughly 3.5 million pages were released publicly. This means approximately 2.5 million pages, roughly 40% of identified materials, were withheld. The DOJ provided several justifications for withholding materials. First, protection of victim privacy and compliance with laws prohibiting distribution of child sexual abuse material. Second, protection of ongoing criminal investigations. Third, attorney-client privilege. And fourth, law enforcement sensitive information. From a legal perspective, these are generally recognized categories for withholding information. Courts have consistently held that victim privacy, investigatory integrity, and privileged communications can justify non-disclosure, even under mandatory release laws. However, the critical question is whether these justifications apply to 40% of the total identified documents, or whether the executive branch is interpreting exceptions more broadly than the legislation intended. Within 24 hours of the DOJ's announcement, the House Oversight Committee sent a formal letter questioning whether the release constituted full compliance with the law. Let's examine the constitutional dynamics at play here. Representative Robert Garcia, ranking member of the committee, stated that withholding roughly 40% of documents while claiming full compliance appears inconsistent with the law's mandate. Representative Ro Khanna, one of the bill's authors, raised similar concerns. This response illustrates Congress exercising its oversight function. When Congress passes a law and believes the executive branch isn't fully complying, it has several tools available. It can issue subpoenas for additional documents, hold hearings to question executive branch officials, and ultimately use its appropriations power to influence compliance. The Oversight Committee has reportedly issued a subpoena to Attorney General Pam Bondi demanding access to the full, unredacted collection of documents. A subpoena is a legal demand for information backed by Congress's constitutional authority. If the executive branch refuses to comply with a congressional subpoena, this creates a constitutional standoff. Historically, such disputes have been resolved through negotiation, through court intervention, or through political pressure. Senate Minority Leader Chuck Schumer has also raised questions about specific aspects of the release, asking whether all documents meeting certain criteria were included. These questions represent normal congressional oversight, elected representatives ensuring executive agencies comply with the laws Congress passes. This situation illustrates a fundamental tension in American constitutional design, the balance between executive authority to conduct investigations and congressional authority to oversee how that power is exercised. The executive branch argues it has discretion to protect sensitive law enforcement information, privileged communications, and victim privacy. These are legitimate executive functions recognized in law and precedent. Congress argues it has authority to demand information necessary for its oversight responsibilities, and transparency laws represent exercises of its legislative power. This, too, is well-established constitutional authority. When these principles conflict, courts often must resolve the dispute. The Supreme Court has held that neither executive privilege nor congressional oversight power is absolute. Both must be balanced against legitimate competing interests. In cases involving criminal investigations, courts generally recognize that ongoing prosecutions may justify temporary withholding of some materials. However, once investigations conclude or when Congress has compelling oversight needs, the balance often shifts toward disclosure. Beyond this specific case, this situation raises important questions about government accountability mechanisms and how they function in practice. Transparency laws are designed to ensure public and congressional access to information about government operations. The theory is that sunlight disinfects, that public scrutiny prevents abuse of power and ensures officials act appropriately knowing their conduct will eventually be reviewed. However, transparency mechanisms only work if they're enforced. When disclosure laws include broad exceptions or when compliance is incomplete, the intended accountability benefit diminishes. This case also illustrates challenges with document-intensive disclosure. When investigations generate millions of pages of materials, the review and redaction process becomes enormously complex. Identifying what must be protected versus what can be released requires significant resources and judgment calls. The question becomes, who makes those judgment calls and who reviews them? When the executive branch both conducts investigations and decides what information about those investigations to release, potential conflicts of interest exist. Some legal scholars argue that independent review mechanisms, perhaps involving judicial oversight or independent inspectors general, could provide more credible assessments of what legitimately must be withheld versus what can safely be released. From a procedural standpoint, several things are likely to happen next. First, Congress will continue demanding additional documents through subpoenas and oversight hearings. Second, the DOJ will either comply with additional disclosure or defend its position that current releases satisfy legal requirements. Third, if disagreement persists, courts may become involved to resolve the dispute.
Congressional committees have scheduled hearings to question DOJ officials about the scope of materials withheld and the justifications provided. These hearings serve both informational and political functions, gathering facts while also creating public pressure for compliance. Ultimately, whether additional materials are released depends on three factors: legal interpretation of what the transparency law requires, political pressure from Congress and the public, and potentially judicial intervention if the dispute reaches courts. What can we learn from this case about how government transparency and accountability actually work? First, transparency laws are only as effective as their enforcement mechanisms. Without strong oversight and consequences for non-compliance, disclosure requirements can be interpreted narrowly by agencies with incentives to limit information release. Second, inter-branch conflicts over information access are inherent to our constitutional system. The executive branch conducts investigations and holds information. Congress oversees and demands disclosure. Courts resolve disputes. This creates tension, but also creates checks on power. Third, public attention matters. Transparency laws often exist because public pressure demanded them. Continued public engagement helps ensure they're actually enforced rather than becoming symbolic gestures. And finally, these cases remind us that government accountability is not automatic. It requires active oversight by Congress, engagement by citizens, and institutional willingness to follow both the letter and spirit of transparency requirements. The Epstein Files Transparency Act case study shows all these dynamics in action. Congressional legislation, executive implementation, oversight disputes, and ongoing questions about whether legal requirements have been satisfied. If you found this analysis of government transparency and congressional oversight helpful, subscribe to News Vault for more educational content on how government processes actually work. What other aspects of government accountability should we examine? How should disclosure laws balance transparency against legitimate privacy concerns? Share your thoughts in the comments. Check out our other videos on congressional oversight powers, executive privilege, and separation of powers to understand more about how these institutional dynamics function. Thanks for watching News Vault, where we explain how government really works. See you in the next one.